25 minutes before the hour, and they're continuing to play this lengthy interrogation of George Zimmerman as part of his murder trial in Central Florida at the courthouse there in Seminole County. Judge Andrew Napolitano is here with us, Fox News senior judicial analyst. Judge, what do you make of the prosecution introducing this as part of its case in chief?
It's a little unusual that the government would do this, especially when his previous 4 witnesses he either argued with or had to cross-examine his own witnesses because they didn't give a version of events that he wanted, and they didn't give the version of events that he told the jury they were going to give. But I now suspect that he may be playing this tape, and the person on the witness stand is the male in the tape who's asking the questions. The detective who decided not to file murder charges against George Zimmerman, the detective who quit his job after he decided not to file murder charges against George Zimmerman because of the outcry against him. I suspect he may have him on the stand just to authenticate the tape and to then tell the jury the differences between what Zimmerman told this detective, who believed him, compared to what the other eyewitnesses told the jury.
So that he's had a rough day with his own witnesses, I mean, it does not portend well for the beginning of this part of his case, does it?
No, he's had a rough day with the first 4 principal witnesses that he put on the stand. This is going back to last week. When I say rough day, I mean they didn't say what he expected them to, and the defense counsel in cross-examination turned them around.
All right, she's the IRS official who's getting paid to do nothing, but lawmakers have a plan that could end Lois Lerner's silent treatment once and for all.
I would hope that Lois Lerner would feel motivated at some point to come share the information she has with Congress, whether that's in the form of a proffer or a limited immunity agreement. Unless your name is Jack Bauer, you cannot make people talk. So we can bring her back, but you can't make someone talk. What you can do is incent them to talk.
But can Congress actually force her to talk? Fox News legal analyst Judge Andrew Napolitano says, yes, they can. What is it called, immunity?
Well, they can give her immunity. I mean, the committee that seeks her testimony by a 2/3 vote can make an application to a judge in Washington, D.C., and the judge, then after hearing arguments from the Attorney General, who's probably against this, would give her immunity. There's different degrees of immunity, but the basics are immunity is involuntary, meaning they can give her immunity even if she doesn't want it. And once they do give her immunity, she would have to speak. And if she didn't speak, she would then go to jail until she spoke. The theory behind immunity is they can't use the information that you give against you, but they can use it against others. Now, this doesn't always work. We have a wonderful colleague by the name of Colonel Oliver North, who was once given immunity, and he testified, and they used the information he gave against him, and he was convicted, and then a higher court overturned the conviction, saying you have to follow the immunity. So there's a lot of case law there. There's a lot of judicial interpretation of it. But the bottom line is, if they give you immunity by a majority vote of the House or a 2/3 vote of that committee and an agreement by a federal judge, you have to talk or you go to jail.
Judge, what I'm wondering, what's your gut tell you? I don't think she's the type of person who will take a deal. She's happy with what she's got, right?
Well, remember, it's not a deal. It's involuntary. They would give her immunity even against her will, and then she'd end up in jail until she decides to speak.
Congress can put you in jail?
Well, the court would put her in jail. Congress would go before a judge and say, Judge, you order her to speak. Judge orders her to speak. She remains silent. Ms. Lerner, if you don't speak in the next 15 minutes, we're going to put you in jail until you do speak. Now, that length of time in jail is about 18 months. After 18 months, which is a long time to be sitting there, for not for a crime, but because you won't talk, most judges say, look, it's obvious she's not going to talk. We're going to let her go.
Real quickly, if that would happen, would she be testifying in front of an open court or in front of Congress or in privacy?
No, it would not be in private. It would be a public interrogation, much like the one where she claimed she took the Fifth Amendment, but then asserted her innocence nevertheless, which probably waived her Fifth Amendment rights, which is the first step towards immunity.
All right, Judge, thanks so much.
My pleasure, guys. This is a saga that's going to go on all summer, I think.
All right, thanks so much.
What an extraordinary choice by the prosecution to play that interview almost in its entirety of our own Sean Hannity interviewing George Zimmerman in that sit-down exchange that happened a year ago, last July, with his attorney, Mark O'Mara, present, and not subject to cross-examination. The prosecution made this decision. That was the prosecution playing that tape. Joining me now to comment on this, Judge Alex Ferrer. He's still with us, host of Judge Alex, and Judge Andrew Napolitano, our Fox News senior judicial analyst, standing by as well. Judge Napolitano, let me start with you. I mean, Have you ever seen anything like this?
No, I haven't, Megan, and it really is a head-scratcher. Judge Ferrer knows more about Florida law and procedure than I do, but it appears as though the government has made a conscious choice to demonize the defendant and to try and demonstrate to the jury slight differences in the version of the same events that he gave at different times before the trial, so as to set him up for a major cross-examination when and if he testifies. But he doesn't have to testify. There has been so much of him in front of this jury at the choice of the government. All of the explanations he gave are lucid. The differences between them are minuscule. I honestly think that the government has been shooting itself in the foot, and with what they did today, they shot themselves in both feet.
Judge Alex, I listen to that. I think that's the defense putting that on.
That's pretty much how the whole case has gone, Megan. I mean, frankly, every day I listen to the evidence, I listen to the testimony, and it feels like the movie Groundhog's Day because everything keeps repeating itself.
Why would they do that?
Witnesses.
Why? But why?
Well,
I realize they're trying to find inconsistencies in Zimmerman's story
Yes,
because he gave
but
several accounts. There's at least 5 accounts, and they're going to try to point here he said this here, but they already have 4 or 5 others outside of Hannity. That exchange, I mean, you tell me, how did Zimmerman come across? What did he say that was particularly helpful to the prosecution? Why would they make the decision to play that?
I think it shows how desperate the prosecution is right now. They're willing to take the little crumbs they can get out of impeachment. He said this instead of that. And they're willing to risk the jury hearing a sympathetic presentation of the self-defense story over and over and over again. I mean, what they got out of this, okay, it doesn't look good for George Zimmerman to say, I think it was God's plan. Really? It was God's plan that you shoot an unarmed 17-year-old boy? That might tick off the jury a little bit.
And FYI, according to our in-court producer, when that piece of that interview played, Trayvon's mother, who is known to be a religious woman, looked away and down from the screen and then later looked over at the jury. Go ahead, sir.
So I think they got a hit on that. The second one was when he asked them about was there a conscious thought in your mind that you were about to be killed? And he said, I wish I could tell you. Well, I guarantee you.
Wait, I'm going to let you finish your point. I'm sorry to be so annoying, but we actually queued that up. And let me play that again for the viewers, and then you'll finish your thought after.
Sure.
Was there a conscious thought that went through your head that you thought you were going to die and that you had to take this, you had to get your weapon and fire?
I'd love to give you an answer.
You don't know.
It just happened so quickly.
Okay, go ahead.
And I think the prosecution is going to jump all over that because the requirement for use of deadly force in a self-defense setting is you must be in imminent fear of death or great bodily harm, and they're going to say he's admitting he can't even say that he was in fear for his life right then. So they're going to use that. However, if you take it in context, which O'Mara, under the rule of completeness, is going to argue you should, well, it's already in evidence anyway, but he's going to argue the rest of the statement, which before that he said, when were you in fear for your life? And he said, when he was smashing my head on the concrete. So clearly, you can't quite parse it out of concrete, but I think it just shows the prosecution is really desperate right now. They've made the self-defense claim. At this point, I don't think you have a chance of seeing George Zimmerman on the stand. I don't
Judge
think he's
Napolitano,
testifying.
I mean, is there any?
He doesn't have to. The self-defense claim has been put before the jury, and now it is the state's burden to overcome it beyond a reasonable doubt.
The state's burden, not the defense's burden.
Yes.
No, not at all. All the defense has to do is present it, and the prosecution did that for them.
That's the thing, Judge Napolitano. I mean, if you, more and more, day by day, as the prosecution witnesses have given so much evidence that is helpful to the defense, not all, of course, some has been helpful to the prosecution, but so much that is helpful to the defense. Is there any way you would put Zimmerman on the stand now? The jury has heard his version, and the man has not been subject to cross.
I can't imagine putting Zimmerman on the stand unless something comes in between now and the time they rest, and I believe that they're close to resting, which compels an explanation from the defense that they cannot get in out of the mouth of another witness. But the prosecution has a weak case here. This is a dangerous intersection of racial politics and law, where the racial politics not animating this prosecution, the prosecutor should be free to say, you know what, this is not a second-degree murder case. Our witnesses are weak. They're going to help the defense as well as they're going to help us. We should charge him with a much lesser crime, and we have a better chance of convicting, or we should not charge him with anything. They're not stupid. They know they have a weak case, and they're putting it on anyway because of the public pressure to prosecute this guy.
That's how we got here. That's how we got here. The police officers did not want to bring charges.
That's not the way these things are supposed to work.
And the state, the Attorney General and the Governor sat down and decided this needed to be pursued, and that's how we got to trial. Gentlemen, thank you both so much. We appreciate your insight.
Bring in our Fox News senior judicial analyst, Judge Andrew Napolitano. So the judge allows this professor to take the witness stand to say the defendant took this criminal justice course. Judge, how is that relevant?
Well, I would not have allowed it, and I don't think it's relevant, unless the defendant takes the stand and professes ignorance of the law. Then you can contradict what the defendant said in order to show that he's not believable in this instance, so you can infer he's not believable in other instances. Stated differently, if the defendant doesn't take the witness stand, then inconsistencies in statements he made to the police or to Sean Hannity or anybody else are not relevant to whether or not he is guilty of this crime.
And the prejudicial effect arguably outweighs the probative value. But let me take it a step further here. The defense, nevertheless, loses the ruling, but uses it to try to convince the jury, hey, there's nothing sinister about wanting to be a police officer. It's a noble endeavor.
Well, not only did the defense astutely do that, the defense also did what you and I were taught in law school years ago to do when the other side's witness is on there. Turn him into your witness.
Right.
Get opinion testimony out of his mouth helpful to you. So when defense counsel says to this professor of law, tell us how stand your ground works.
Right.
You don't have to be bleeding to death before you can defend yourself, do you? Oh, no. You only have to have reasonable apprehension. That's all we wanted to hear. Thank you, Professor. And he did that in a little bit longer than I've just done it. I summarized it. But it's very, very effective with the jury in behalf of the defense.
Well, I was a little surprised that they allowed this professor to suddenly opine on the critical issue of self-defense here. Because at one point in time, the professor then confuses the notion, the doctrine of imperfect self-defense with excessive force.
Well, yes, and that, A, can confuse the jury.
And it likely did.
And B, I will tell you, judges don't like professors on the witness stand telling the jury what the law is. Judges like to tell the jury what the law is. So it's highly unusual for her to let this guy testify in the first place of his opinion. He can testify to what he taught the defendant, but for him to say what he thinks the law is, very unusual.
And he got it wrong. He gummed it all up. I'm
Yes.
throwing stuff at my TV set when he confuses imperfect self-defense with
He did
excessive
get it
force.
right, though, when he said, how much fear do you have to have before you can use deadly force? And that answer was strikingly helpful to the defense, not to the government.
Well, at its core, let's put up self-defense, because here is essentially an abbreviated form of the jury instruction. This is what they really should consider and not what the witness said. A person is justified, can we put it on the screen? A person is justified in the use of deadly force and does not have a duty to retreat, i.e. stand your ground, if he reasonably believes such force is necessary to prevent imminent death or great bodily harm to himself. The key word there, Judge?
Reasonably.
Reasonably.
Yes, and the way it's worded, it would be subjective. That is, it wouldn't be what a reasonable man would do. It's what this human being reasonably believed in his own mind. Even if that belief was unreasonable, if he entertained it, it's valid.
All right. Now let's go back to what was broached on the witness stand by the professor. He started to try to define imperfect self-defense. The truth about imperfect self-defense is it is an honest but mistaken belief that your life is in imminent danger of serious bodily injury or death. It's a qualified defense. It's not pure excuse.
Well, that's right. Sometimes I think that the government here is so assaulting Zimmerman's thoughts and ways of expressing himself because they want to goad him into getting on the witness stand. They'd love nothing more than to have him sit down, as Sean Hannity did, but here under oath and obliged to tell the truth with all of these inconsistencies. On the other hand, they have gotten so many versions of his events out there, all of which help him. There may be some inconsistencies in them, but if he has a reasonable but mistaken belief that he is in jeopardy of his life, he can use deadly force, which he did.
Yeah. On balance, it's been 8 days now of testimony. The prosecution's case. but most of the witnesses have been more beneficial to the defense than the prosecution, in your judgment?
Not even a close call, Greg. I would be calling the prosecutor up there and saying, why are you presenting this case? Are you presenting this case because of race, because of politics, or because you think you can win it? Because in this courtroom, you haven't crossed the bar yet of what it takes to win this case. I'm in danger of dismissing it. This is what I'd be saying to them at sidebar, out of the presence of the jury, because so far they're wasting everybody's time. That's how tepid, that's how weak their case is.
Well, prosecutors originally didn't want to charge. Wasn't enough evidence. Only when politicians got involved and appointed a state prosecutor who doesn't have to try the case did they decide to charge.
You're right on the mark, Greg.
All right, Judge Andrew Napolitano, as always, good to see you. Thanks,
Pleasure.
You're going to stick around as we continue
Oh, yes,
to watch
this is fascinating stuff.
All right. In the meantime, the George Zimmerman murder trial is certainly underway today, and right now a crime laboratory firearms analyst testifying about the gun that Zimmerman used when he shot Trayvon Martin. Let's bring into the conversation our Fox News senior judicial analyst, Judge Andrew Napolitano. Obviously, they have to authenticate and demonstrate the chain of custody of the weapon that was used here. She's done that already. She said it was a shot fired at basically point-blank range.
Right.
We have heard that the defense may have an expert of their own who will be able to say that Trayvon Martin was on top, leaning forward, attacking based on the angled trajectory and other forensics.
All right, well, here's how it works. When either side is going to produce an expert, and an expert is permitted to give his or her opinion to the jury in the field of expertise, the expert writes a report, and the reports are exchanged. So the defense knows what this lady is going to testify about, and the prosecutors know what the defense expert, if he or she testifies, will testify about. We haven't seen those reports, so we don't know where she's going. Thus far, she has very professionally, methodically, and without controversy related what she discovered. This bullet came out of this gun and made this hole in this clothing. She may also be anticipating defense expert testimony that Trayvon was on top of Mr. Zimmerman at the time Zimmerman fired the shot. She hasn't gotten there yet, but she may be going there, in which case she would give an opinion the opposite of that.
Right.
Now, how can two experts looking at the same scientific data come up with opposite opinions? That's what you have experts for, Greg.
Reasonable minds can differ.
Yes, they usually do what the person paying them, the state or the defendant, wants them to do, but within the realm of reasonableness and as their discipline permits.
In my years as a defense attorney, I could always find somebody who could present my point of view. And the cynic that I became said,
cynical?
I could buy an expert to say anything. I used to say that all the time.
Look, there's an old joke about experts. You say to the expert, what is 2 + 2? And the expert says, what do you want it to be? Whatever you want, I'll say. I don't want to diminish it.
Right.
Because the court listens to this expert testimony first and makes sure it's scientifically sound, and then gives them a little leeway on the ultimate opinion.
All right. In the end, it may prove to be a wash. We'll wait and see as the testimony continues to unfold inside this Florida courtroom.
We'll go there for testimony in just a moment. First to our legal panel, defense attorney, Fox News legal analyst, Studio B contributor Arthur Aidala, and Fox News senior judicial analyst, Judge Andrew Napolitano. How do you assess this day, Judge?
Very good for the defense, as most of the trial has been, Shep. The issue of whose voice was it, because the jury doesn't recognize the voices, and George is not going to testify. George Zimmerman, Trayvon Martin obviously can't. It's going to be determined by the witnesses. The defense witnesses were far more credible and certain that it was George Zimmerman's voice. So today is clearly going in the defense direction. But I'm of the belief that the whole trial has been going in the defense direction. And if he begins to put more of the cops on the stand, as he just did, and elicits more favorable information out of the mouths of the government's witnesses, favorable to the defendant, what's even remaining of the government's case will be in a shambles. All right, why are we going through all this? Because the government's theory of the case is that George Zimmerman engaged in sort of acrobatics in the manner in which he...
Those effing punks, they always get away.
Correct. And
that's where they begin.
The manner in which he subdued Trayvon Martin. So he doesn't want to put his own client on the stand, so he brings in the personal trainer who trained this guy to say when he came to me, he was a 0.5 on a scale of 1 to 10, the lowest of the low. And when he left me a year later, he was a 1.0, very close to the lowest of the low. The guy still was not very physically dexterous. That's why this person was on the stand, and that's why this is an issue in the case. The trainer pretty much stuck to his guns. Prosecutor showed the trainer to be a little bit of an annoying wise guy, but he didn't shake him from his version of events that George Zimmerman probably could not have done the acrobatics that the government says he did.
If you are engaged in physical confrontation with someone and you believe, that's the standard in Florida, if you believe you are about to die unless you take extraordinary measures, I'm about to die in the middle of this conflict unless I fill in the blank. In this case, fill in the blank is take the gun off my side and shoot the person who's trying to kill me. That's the standard.
That's the standard, and that's why that tape, Shepard, means so much, because that's not a guy going, hey, get off of me, hey, get off of me. I mean, it's like someone screaming in agonizing pain and fear. That's why that tape means so much. That's why there are all of these witnesses. What have there been 6 witnesses between both sides on maybe more than 6 witnesses on whose voice, who's screaming, pleading, because that goes a long way in what's in someone's mind.
Of course, along the way, we're speaking only in hypotheticals and not taking sides, all right? If George Zimmerman were to have started this thing, those effing punks, they always get away, and then all of a sudden realized, holy goodness, this guy's about to kill me, and brought out his gun and shot, where does that leave us?
He can still defend himself.
If
the dynamics change, if he's the aggressor, but at some point during the process becomes the victim and believes that he's in danger of losing his own life, he can legally use deadly force to save himself, even though he started it. That is a value judgment criticism of the stand your ground law in Florida, but nevertheless, it is the law.
Any reason, Judge, to put him up there?
But look, there are lawyers who believe, and I agree with everything Arthur just said. There are lawyers who believe that in a self-defense case, the jury wants to hear the explanation of self-defense out of the mouth of the defendant. However, in this case, the defense has done a truly brilliant job of getting his own words out of his own mouth before the jury without the ability to cross-examine. Cross-examination is very, very dangerous for this witness or for this defendant because he has given several versions of this. The essence of those versions, however, is the same. Could the court find, could the prosecutor find some holes in what he said? Could the prosecutor catch him in some lies? Yes. Has he lied? He probably has. All that lying is irrelevant if he doesn't take the stand. All that fear is out of the picture if he doesn't take the stand. If they quit today, they win.
Just in the time that the two of you have been involved in the law, which frankly isn't really that long a time, there's been such an enormous change in that when Arthur first started practicing, and when you did, Judge, the chances of being able to go out with a camera to a crime scene and, quote, reenact, unquote, this whole thing, it just did not happen. Think of what it would take to get a camera. Just when I started in journalism, which is, we were dipping film in the soup.
Right.
I mean, this could not be done. Now there's a way to allow this defendant to testify without being cross-examined. And I wonder if there's been a hue and cry about this, if there's been a push to change the rules of evidence. And I'm just curious.
Well, this really cuts both ways. I mean, the government can use high-tech equipment to present its case, and the defense can use high-tech equipment. In the 150 jury trials that I tried, most as a judge, most of which were criminal cases, we never saw anything like this, because the advent of this type of a device to record what you see on the street or quickly record an interview between a government investigator and the defendant or an eyewitness is relatively new, and the accuracy of it is unquestioned. The ease of presenting it in the courtroom is unquestioned and universally accepted.
The other thing is, though, Shepard, the prosecutor put this in.
I know.
Judge, correct me if I'm wrong. I don't think the defense would have been able to put that in.
The prosecutor put it in.
It's a self-serving statement that they can't put it. It's hearsay. It's not subject to cross-examination. The defense can't just put it in.
Their effort to impeach him, to call into question his intellectual honesty and his accuracy, is irrelevant and will fall on deaf ears if he doesn't take the witness stand.
On a whole bunch of fronts, we've kept that promise. This is the most transparent administration in history.
But the administration that promised transparency now trying to cover up a big secret, the files on the Osama bin Laden raid being purged from Defense Department computers going to the CIA, where they can be more easily kept from ever going public.
Joining us right now, Fox News' senior judicial analyst, Judge Andrew Napolitano. Judge, does this surprise you?
No, it doesn't surprise me. If you look at the president saying this is the most transparent administration in history, I don't think even he believes it. I think he's just saying that for public consumption. He knows this is the opposite. This is the most secretive administration in history. Look, the policy of the federal government, this is enacted by the Congress under the Freedom of Information Act, is that every American is entitled to know whatever the federal government does. The federal government is entitled to certain exceptions from that, one of which is national security and spying. So if you take documents and send them over to the CIA, you automatically exclude them from access to the public.
Well, what's extraordinary about this is, okay, now they've put it over to the CIA, it's a secret. But as soon as, the raid was completed, you got Joe Biden on television saying it was the Navy SEALs. Next thing you know, the administration is cooperating with Hollywood. They're making a movie. They're writing books.
That's what's so offensive about what the administration is doing. They are keeping secret from the average American what they don't want us to know for whatever reason. It didn't go the way they wanted. They were embarrassed. They did something that they shouldn't have to answer for. But selectively leaking. This administration persuaded a federal judge about a year ago here in New York City that its legal arguments were secret. The published public opinions which it read and on which it based its argument were so secret, even though they're in public libraries, they couldn't tell the judge what they were. The judge accepted that. 3 weeks later, these legal arguments showed up in an NBC newsroom, leaked by the administration. So the same administration that wants to prosecute leakers, I'm not talking about Snowden, it's a different story. The same administration that wants to prosecute leakers will selectively leak in order to make itself look good. But to take documents, something as profound as the execution of Osama bin Laden, and remove them from the availability of the Freedom of Information Act, unprecedented, unheard of, and unforgivable.
You got to wonder what's in there that they don't want the world or the American public to know. Judge, thanks so much.
Pleasure, guys.
All right, let's go to some new questions now about whether President Obama is stretching the limits of his office by delaying parts of his health care law and which parts he might want to ignore. According to the legislation passed by Congress 3 years ago, the employer mandate, which the president now wants to delay a year, quote, shall apply to months beginning after December 31st, 2013. So is President Obama violating his oath to uphold the laws of the country? Judge Andrew Napolitano is Fox News senior judicial analyst. And one of the reasons we bring this up, Judge, is because some members of Congress have said that they might pursue this, that they believe that they sign this into law and that the president, it's his duty to implement it.
You know, this is a murky area of the law, and presidents, since Thomas Jefferson, have said publicly, there are parts of the law that I disagree with or that I think are unconstitutional. I'm not going to enforce it. It's hard for the president to believe that he disagrees with this or that this is unconstitutional, since this is the centerpiece of his presidency. This is basically the part of Obamacare that says to all entities that employ 50 or more people, you shall make available health care and it shall have these services, as you say, from the months beginning after December 31st, 13 or January 1st, 14. So why would he delay it by a year, and can he? Why would he delay it? You can speculate it. Maybe he doesn't want this to kick in before the congressional elections in 2014.
Some have speculated.
Because he knows it's likely to raise insurance premiums and deny some people the affordable health care they once had. Can he do it? Well, he's not supposed to do it, and he's taken an oath to uphold all the laws, but there's little that anybody can do to stop him from doing it. No one could really sue him and get a court to order him to enforce the law as it was written, because that would be the courts telling the president how to do his job, and the courts are reluctant to do that. When President George W. Bush signed into law, in the act of signing into law, a statute prohibiting federal agents from reading mail without search warrants, he said, I'm signing this into law, but I have no intention of enforcing it. And in fact, he didn't enforce it. And I'm not just picking on George Bush. As I said, Thomas Jefferson did this as well, and every president in between.
It seems ridiculous on the face of it in many ways, you know, when you look at it like that. And when I look at the language of the bill, it seems like typical legalese to me to say in the months after. It doesn't say which month after. It doesn't say as of January.
Right. I'll also tell you how ridiculous the statute is, because the statute, this section of the statute also says it shall begin in the month beginning after December 31st, 2014, or the months after.
The months after.
But it also says subject to rules promulgated by the IRS. The IRS can promulgate any rules the president tells them to.
You could drive a truck through that loophole, right?
Exactly. So we really don't know where we're going. The only time the Supreme Court looked at this was when President Nixon decided not to spend money that the Congress had budgeted. And the court said, you can't do that. You can't impound funds.
They have the power of the purse.
They tell you to spend money, you have to spend it. We're not going to tell you how to spend it or how to regulate, because that's your job, Mr. President.
Congress
but you must
has no,
spend
I mean, we're supposed to have 3 equal parts of government.
Yes.
Right? The legislative, the executive, and the judicial.
Theoretically.
Theoretically. But this would suggest that they're not. Because if you're a member of Congress who fought to sign this into law, and you got it signed into law, and your feeling is that unless we implement this thing, all the parts of it, the rest of the parts don't work. They rely on each other to work.
Listen,
what's your beef? What's your leverage?
I condemn this statute, and I believe the Supreme Court was wrong to uphold it. But if members of Congress sue the president to force him to enforce it, they will at least force the courts to do something with that lawsuit. They may say, you don't have the right to sue, you don't have standing, or, you know what? A lot of people are going to suffer if this thing isn't in force because they dropped their health care because they knew their employers had to make it available to them.
Yeah.
So I would encourage members of Congress to file those lawsuits, but I'm not optimistic about their outcome.
To see what would happen. You know, I mean, on the face of it, in terms of the law, the health care law, as it holds up, what about that? Does it fall apart once you start to pull out some of the pieces of this puzzle?
Yes, it does fall apart if you pull out the pieces of the puzzle, because a lot of people were planning to have health care offered to them by their employers on January 1st of 14. Not January 1st of 15, January 1st of 14. And a lot of insurance carriers and employers, including our own, had been preparing for that. Now, all of a sudden, there's a delay. Why the delay? Who covers these people during the interim?
More ambiguity.
Exactly, and more uncertainty.
Yeah.
And uncertainty is the opposite of what the law is supposed to bring.
Judge, thank you very much.
Pleasure, Martha.
It's all perfectly clear now, right? Good to see you, Judge.
Tough to
see you
make
next
clear.
time.
He was one of the nation's most wanted fugitives, 83-year-old James Whitey Bulger, the alleged former leader of Boston's Irish Mafia, also the Winter Hill Gang. He was captured back in 2011 after nearly 2 decades on the run. He's now currently on trial for a long list of crimes, including 19 killings. Judge Andrew Napolitano, a Fox News senior judicial analyst, is with us, and I guess there were some fireworks in court yesterday. A guy that he hadn't laid eyes on in something like 16 years, Kevin Weeks, a former enforcer or a heavy for his gang, is testifying in court and, referred to Bulger as a rat. That brought all kinds of fireworks.
Yeah, the government contends, it's in the process of proving its case, and candidly, the evidence of guilt is overwhelming, but the government contends that this witness yesterday was an enforcer for Mr. Bulger and literally killed people at Mr. Bulger's instructions. And now this guy, and this is typical of mob cases, is turning evidence in favor of the government and against Mr. Bulger, and of course Bulger wasn't happy about it. So the question is, I suppose, how do jurors react when the defendant stands up from the defense table and uses 4-letter barnyard words to describe a witness who's just testified against him?
What is that? So answer your own question. What does the jury think?
I think the jury understands the animosity between the two. Mr. Bulger does not help himself because he basically doesn't say, you're lying, it's not true. He's saying, you're not being faithful to me. So I think the jury fully understands what's going on, and Mr. Bulger would be a lot better not to say these things. On the other hand, I don't think it matters what Bulger says. He's extremely likely to spend the rest of his life in jail.
And this judge, this federal judge, Denise Casper, ends up jumping to her feet and screaming at both of them, hey!
Well, here's why she did that. Because this is a long, tedious, expensive case. He could say, Mr. Bulger could say some things which would be so disruptive that it would be a mistrial and they'd have to start all over again. She doesn't want to do that. She, as the court, and everybody that works for her, and almost everybody in that courtroom on this side of counsel table, has worked long and hard, thousands of hours, to get this case ready and to put it on for the jury.
This is apparently his third outburst in the last week or two. It's my understanding that his defense team has been talking about the possibility of putting him on the stand to try to salvage his reputation. If this is the kind of behavior he exhibits in the courtroom, that doesn't seem like it would be such a good idea.
No, the only thing that it would salvage would be his ego, because it would give him the last word, or not the last word. The jury will have the last word, and then the judge will have the last word at the time of sentencing. But it will let him state aloud what he's been thinking. But it's not going to affect the outcome of the case. This is a very, very volatile witness. Defense counsel would be ill-advised to put him on the stand. He's going to seal his own fate. Perhaps he knows that, and he just wants one last opportunity to speak aloud to his formerly adoring public.
And cameras rarely allowed in federal court, so we don't have this outburst.
May I modify that? Never.
I thought they could be allowed in certain circumstances.
No, not in federal court. This would be a great case if we could be watching it like we are the Zimmerman case. But
Jenna wants to watch it, right, Jenna?
I do. It was very colorful language.
Yes, Jenna, but you're not used to hearing words like that.
I've never heard it before in my life. Judge, thank you.
You're welcome.
It's ending up being one of the most watched trials of the year, and it's wrapping up. Closing arguments begin today after George Zimmerman decided not to testify. Now, will the judge lower the charges, at least instruct the jury that they consider other charges? Joining me now, Fox News senior judicial analyst, Judge Andrew Napolitano. Good morning to you, Judge.
Good morning, Gretchen.
All right, so let's back up, because you, in fact, believe that this case should have never even gone forward. Why?
I do believe that this case was largely brought because of what I would call racial politics. Fear that animosity between the races, since the decedent is African American and the person who killed him is Hispanic, part Hispanic, part white. And the government thought that by bringing the case and putting the burden on the jury, it would get rid of the animosity between the races. But that's not the reason for which we have criminal trials. We have criminal trials when the government has enough evidence to convict. It is clear the government doesn't have enough evidence to convict. The case should have been dismissed by the court at the end of the government's case. I don't blame the prosecutors. I've watched this case, and in my view, the two of them are superior professionals. I blame their bosses who compelled them to try this case and to charge the defendant with far more than they could possibly prove.
So it's second-degree murder charges.
Well, okay. In most states, if you charge with for second-degree murder, the jury could compromise at something below that. In Florida, the jury can't unless the judge decides that they can.
So that's the big decision today.
Yes, the government lawyers are going to say to the judge, just in case we didn't prove second-degree murder, would you tell them that other types of manslaughter, other types of homicide, aggravated manslaughter, simple manslaughter, are capable in there, and they could convict of that even though we didn't actually charge him with that.
So do you think the judge will do that?
I think this judge will, and I'm critical of her because she's not doing what she should be doing, which is throwing out charges where there's inadequate evidence. She's putting the burden on the jury. Let these 6 anonymous people bear the consequences for an unpopular outcome rather than me, the judge, the professional, doing her job.
Okay, there's been much made of the judge yesterday. Some people thought admonishing going too far and asking Zimmerman whether or not he was in fact going to testify. You feel differently than some. Do you think, did she go too far?
It is not clear to me if she asked the questions at the right time, but it is clear to me that the questions were acceptable. When you are the judge, you have to be absolutely certain of a couple of things. One, that the defendant knows that he has the right not to testify. 2, that it is the defendant's own decision, that his lawyers are not making him do it, and no other person is making him do it. Because that decision not to testify is irreversible. It can't be undone. And so the judge is required to ask the defendant, outside the presence of the jury, questions so that the judge is satisfied with the answers.
All right.
We don't usually see that happen on TV, and some people were a little startled by it.
Right.
The judge interrogating the defendant. You have to do it.
All right. Thank you so much for the analysis. Nobody does it better. Judge Andrew Napolitano, thank you.
You're welcome.
Simply on the basis of what Ambassador Rice has publicly disclosed, does the United States government regard what happened in Benghazi as an act of terror?
Again, I'm not going to put labels on this until we have a complete investigation, okay?
So you don't regard it as an act of terrorism?
I don't think we know enough. I don't think we know enough.
So what about the questioning today and where this goes? Let's bring in our panel tonight. Judge Andrew Napolitano, Fox News senior judicial analyst, Mara Liasson, national political correspondent of National Public Radio, and syndicated columnist Charles Krauthammer. Okay, Judge, you saw some of the questioning today. Thoughts?
I watched almost all of it, and I'm very, very, very frustrated because in my former forum, the the questions would have been more pointed and she would have been compelled to give precise, specific answers to the questions. I think that the Senate is institutionally incapable, in part because it's in the hands of the Democrats, in part because these guys and gals are not professional cross-examiners, and in part because she doesn't want to give answers, of getting truthful answers out of her. And I don't think the legislative process will ever get the truth out of this administration as to what happened in Benghazi. How do they get the truth? Probably some sort of an independent prosecutor or the next president's Justice Department. But this is deeply and profoundly frustrating. She obfuscated better than Susan Rice did.
It is a disturbing trend, Mr. President, when Republicans are willing to block executive branch nominees, even if they have no objection about the qualification of the nominee. They don't like the law. They don't like the agency. Instead, they're blocking qualified nominees to circumvent the legislative process, force wholesale changes to laws, or restructure entire executive branch departments.
And it's noteworthy that all of the people he's complaining about all got confirmed. So what he's really saying here is he don't want any debate at all in connection with presidential appointments. Just sit down, shut up, and rubber stamp everything, everyone the president sends up here.
Well, that's the back and forth on the nuclear option. The Senate Majority Leader saying he has the votes to change the Senate rules with regard to the executive nominees. The executive nominees, not judicial nominees, not policy, but executive nominees. We're back with the panel. Judge, you know, this essentially means that instead of getting 60 votes for what's called cloture to move on, move forward, they would only need 51, a clear majority. They would change the rules of the Senate. What about this?
Well, I think that Harry Reid would rue the day that this happens, because at some point he's going to be, the Democrats will be in the minority, and the filibuster is a tool of the minority to prevent the majority from steamrolling. It slows down the government. From my worldview, it means fewer nominees, fewer laws passed, and that's a good thing. I think that it's terrible that they want to get rid of the filibuster rule. I don't know that he has the votes to do it. I mean, I've been reading statements from Democrats this afternoon that they agree with me, that they want to have that tool available to them when they're in the minority. But he will go down, as Mitch McConnell said, as the worst majority leader in modern times if he takes this tool away from the minority.
You know, he says he has the votes. We'll see if he does or not.